Yes, I would agree with what you have said and also what Elizabeth said before. In my view, we are getting quite a lot of cases which are like Amazon Louboutin, like Coty, like L'Oréal, so all the infringement situations or intermediary liability. We are getting a little bit closer to have a real understanding of what is the threshold of acceptable things to not acceptable things. And it's really like, I think this last Louboutin Amazon is very clear on that. As long as it is clear for the customer who is responsible for the selling of the goods, then the liability of the company is more or less excluded, to say it, to simplify it. And back to Elizabeth's idea, I would also say that the current case law really goes to understand that the internet age is coming, and we are having the same principles as we used before on the internet aspect. So if you have, for example, all kind of evidence of use by internet pages, you really count them. You have now all these possibilities to see search engines numbers coming to a country. So once more back to the territoriality, and you see if I refer once more to the Louis Vuitton, if you see just 1% of customers in Slovakia or in Bulgaria have seen a certain kind of graphic and understood it's trademark related, then it's maybe not enough, but you can have all the other calculations to add on the global level, as you would have done in the past in the non-internet age. So I suppose it will be even more interesting with all the cases on this metaverse and NFTs coming, but we don't have so much of that yet. And still, yes, the problem is that you have the legislative part, like the DMA, DSA in Europe, which goes, I think, quite a lot of steps further. But then as to the case law, I completely, Iris, agree with you that you are a little bit limited by the facts of each of the cases, and therefore you create principles which might not be always comprehensive for all the situations which you could see in practice.